Okay, hello. So the purpose of this presentation is to give you guys a brief overview of copyright law as it pertains to higher education. So we'll start out with the PowerPoint presentation, then I'll give you a tour of a website that I created, which will be available to you after the session to answer any questions that you have. And then we'll spend the rest of the time just chatting about whatever copyright issues are most relevant to you guys, and hopefully I'll be able to answer any specific questions that you have. But if you could just hold your questions to the end, we'll do Q&A at the end of the session. So whenever I talk about copyright, I like to begin at the beginning with the U.S. Constitution, which endows Congress with the right to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So the first takeaway is copyright exists for a reason, and that reason is because the Founding Fathers thought that it was beneficial to society. How does copyright accomplish that? Through 6 exclusive rights. So only the holder of a copyright has the right to make copies of the work, to prepare derivatives from works from that work, to distribute copies, perform or display the work publicly, or to transmit the work. If anyone else wants to do one of these 6 things with a copyrighted work, they have to ask for permission. And the copyright holder is able to, if they want to, charge for that permission. It's this last part, the permissions process and the charging for permission, that tends to get most of the attention when people talk about copyright. And when they talk about permissions and fees, they tend to only focus on part of the story. So you see rights holders upset because people are using things like peer-to-peer file sharing software to avoid paying them rights. And you see people like professors complaining about the permissions process as something that's places an undue burden on them. But the thing to remember about copyright is that copyright is a two-way street. So yes, a rights holder does have the right to earn income from their work, but only to the extent that it inspires them or encourages them to create new works. And the same is true of the permissions process. So when I did this PowerPoint, I wanted to use images to spice it up. So I had to ask for permission to use those images, which did take time and was a pain in the neck. But that same process is also the thing that enables me to put this online without being afraid that someone is just going to take my slides and give a presentation and claim it as their own creation. So it is a two-way street. It works to the benefit of both the creator and the user. One way to think of copyright is as traffic laws, continuing the road analogy, which enable us to get where we're going without killing each other. And that actually leads me to my next point, which just as our current traffic laws don't necessarily account for things like flying cars, the bulk of copyright law, which was written in 1976, doesn't necessarily provide concrete answers to a lot of the questions that people have. So streaming video, to just name one for instance, did not exist in 1976. So when we go to the law is intentionally flexible on many points, which was intended to allow it to evolve. But we don't always get those concrete answers that we're looking for. My purpose today is not to tell you what you can and can't do. It's to give you tools that you can use to make an informed decision about what you should do and about what, depending on your tolerance for risk, you want to do in relation to copyright. That said, as recently as March 20th, the Register of Copyrights did call on Congress to think about the next great Copyright Act. So hopefully there will be legislative answers coming in the relatively near future. But for the time being, what we have is an imperfect law that is probably a little bit outdated, but we work with what we have. So that's the purpose of the presentation today. So requirements for copyright protection, they're actually pretty simple. Anything that is an original work of authorship that is fixed in any tangible medium of expression is automatically copyrighted. So you don't need the little C in the circle. You used to, which is a point of confusion, but since 1978, you do not need to mark your work as copyrighted for it to be protected. So any original work of authorship fixed in any tangible medium of expression is automatically copyrighted. That means, for instance, that my PowerPoint slides are copyrighted without me doing anything. They're automatically protected by copyright. What isn't protected are ideas, procedures, processes, systems, methods of operations, concepts, principles, and discoveries. This is a little bit confusing, but one way to think about this is what this is saying is you can't copyright an idea. You can copyright the expression of an idea, a work. So a recipe is not protected by copyright because a recipe is any one of these things, it's a process, it's a system, it's a list of ingredients. But if you publish the recipe in a cookbook, that cookbook is protected by copyright. So your instructions, mix 1 cup of flour with 1 cup of milk, that, if you put any kind of thought into it, if you have any kind of literary quality to it, is probably protected by copyright. So your instructions are, but your ingredients aren't. It's kind of one way to think about it. And like I said, that is a little bit tricky. We can come back to that later. Duration of copyright. This is, at least for works after 1978, a little bit more straightforward. So anything created after January 1st, 1978 is protected for the life of the author plus 70 years. So these PowerPoint slides are going to be protected for 70 years after I'm dead. For that whole time, these are protected by copyright. Works made for hire, which very shortly we'll talk about that definition, are protected for a little bit longer, for 95 years from publication, or 120 years from creation, whichever shorter. Unpublished anonymous or pseudonymous works, or unpublished works when the date of the death of the author is unknown, 120 years from creation. Works created before January 1st, 1978. This is where it gets a little bit complicated. I say it depends here, and this is why. For works created before 1923, it's pretty straightforward. They are in the public domain. There's a few exceptions to this, but as a rule of thumb, that's safe. Works created after 1978, as I said, are not in the public domain. They're protected by copyright. Anything in between, it depends on things like, if it was published between 1923 and 1977 without a copyright notice, the little C in the circle, it is in the public domain, because during that time you did need to put the copyright notice down. Also, at various points, you were required to renew your copyright. So if your work was published between 1923 and 1963 with the notice, but you didn't renew the copyright, then again, the work is in the public domain. So it can be pretty complicated. This chart is actually on the website I created, so you can consult this if you need to, but that might be a place where it's a good idea to consult an expert if you have questions about that. Joint works, collective works, works made for hire. So authors of a joint work, that's if 2 people work together with the intention that their efforts be melded into one whole, they are co-owners of the copyright. So these slides are actually based on a presentation that I did with Anita Tiernan to a faculty meeting in March. Since we worked together on that, we are the co-owners of that copyright. That means I have the right to adapt these slides into a new presentation as I did today. If I were to make money after this, I would have to find a way to split those profits with Anita, because we're co-owners. So each of us can use it, but we have to share whatever money we make off of it. Copyright in each separate contribution to a collective work is distinct from copyright in the collective work as a whole. So what that is saying is, if we have something like words and music for a musical, the copyright for the words and the copyright for the music are actually distinct from one another, and they're distinct from the copyright for the work as a whole. So to use more than one person can own copyrights for more than one part of a work. So that applies also to online classes. If you have, say, slides that a professor put together, that's one copyright potentially. If you have a video recording of a lecture, that potentially could be something that the videographer holds the copyright to. If there was somebody in IT who helped put together the website, that might be a third copyright. So you can see how quickly this can become pretty complicated. But the thing to remember is that each distinctive part potentially has its own copyright. Lastly, works made for hire. And this is one that's particularly relevant to higher education. The default setting, as it were, the employer owns the copyright to any work made for hire unless the parties explicitly agree otherwise in a signed written instrument. Work for hire, the very brief explanation of that is if it's something that's done in the course of the work that you're employed to do. That's almost certainly a work made for hire. What that means in the higher education context is most of the things that we create in the course of our work, whoever our employer is, in this case McDaniel College, probably owns the copyright to those works. So if we're talking about course materials, because you're a professor, the college probably owns the copyright to those works. And you can only change this with a signed written instrument. So if you want to own the copyright to anything you create, you need to negotiate that with your employer, or else the default setting is going to be that the copyright belongs to your employer. Exceptions to copyright. So this is the good part. So we just talked about all the things that are protected by copyright and the rights that those entail. As I said at the outset, the copyright law exists for the betterment of society, and the law recognizes that sometimes society is actually better served by allowing for the circumvention of copyright. And there's a number of ways that this is accomplished. These are the ones that are most relevant to higher education. And the one I'm going to start with is, I think, the mother of all exceptions is fair use. Fair use applies to all situations. So whenever you have a situation where you want to use a work, if it was published after 1978, you should assume that it's protected by copyright, which means that you would have to ask for permission to use it, unless your use qualifies as a fair use. Fair use is designed to protect certain uses that are beneficial to society, so that would be things like criticism, comment, teaching, including, and it says this in the law, multiple copies for classroom instruction. So these are some of the purposes that are okay. So with fair use, how it works, there are 4 fair use factors. If you want to know if something qualifies as a fair use, you look at each of these factors in turn and you try to determine whether or not the factor favors you or favors the right holder. So the first, as I said, is purpose. So basically the main criteria here is, are you doing it for private gain or are you doing it for the betterment of society? So is it a commercial use? Is it a non-commercial use? Nature of the copyrighted work, this is asking what was the thing created to do. So when it's a work of scholarship, which was published for the benefit of society, that's one consideration. If it's a work that was designed to make money, something like a Disney film, that would weigh in favor of the copyrighted work. Another something to consider here is the idea of transformativeness. Are you using the work for its exact intended purpose, or are you creating something new through your use? Amount and substantiality of the portion used is pretty straightforward. How much of it are you using? Are you using the entire work, or are you just using a portion of it? And effect upon the potential market for or value of the copyrighted work. So again, this is asking, are you depriving the rights holder of income that they're entitled to? Or is your use the kind of use that they wouldn't be able to monetize or that they weren't intending to monetize? So what fair use isn't is hard and fast guidelines. And this is disappointing to people sometimes who really just want to know how much of blank can I use. So you see guidelines like this get disseminated pretty widely because they answer that question. So they'll say things like a complete poem is less than 250 words and is printed on not more than 2 pages. The problem with these guidelines is that they're just that, they're guidelines. This does not carry the force of law. The law doesn't work this way. There are no hard and fast guidelines in the law. The law is for things that we consider. It's very subjective. So what fair use actually is a balancing act. You look at the 4 factors and you say, does this favor me or does this encourage me to ask for permission? And one way that you can perform this balancing act is one thing that a lot of librarians, for instance, some librarians at Columbia University have done are create checklists. And what the checklists do is they take each of the 4 factors and they break it down into things that favor fair use and things that favor asking for permission. So what you can do is you can go through the 4 factors one at a time and check off the boxes that apply to your work. And if you end up with more boxes in favor of fair use, then that factor probably favors you. If you end up with more boxes on the other side, then it probably doesn't. And what you're going for here are 3 or more factors. 3 of the 4 factors or 4 of the 4 factors that favor your use. If you get that, you can generally proceed with impunity. If you get less than 2, you generally have to ask for permission. If it's 2 to 2, that's when, again, we're back to just a balancing act. And I have copies of the fair use checklist, which I will hand out after we're done. And these are also on the website that I created. So that's how fair use works. And like I said, I'm sure we'll get into that in the question and answer session, because that is pretty complicated. But the other exceptions are more straightforward, but they also apply more narrowly, so they're less likely to help you, but they're easier to understand. There's a bunch of exceptions for libraries. Libraries are permitted to make copies of work for preservation or replacement, private study, and interlibrary loan, provided certain conditions are met, and we won't get into those. Libraries are also free from liability for unsupervised copy machine use by library patrons, provided a notice of copyright is posted at the copiers. And lastly, libraries are permitted to copy and distribute audiovisual news programs, again, provided certain conditions are met. So that's some stuff that libraries can do. Also applying to libraries, the first sale doctrine. So the first sale doctrine, in a nutshell, is how Hoover Library exists. The first sale doctrine says that if I buy a DVD, once I own that DVD, I'm entitled to do whatever I please with that DVD. So I can resell it, I can loan it to people, I don't have to ask for permission each time. Once I own it, I own it. So that's, said libraries wouldn't exist without the fair use first sale doctrine. It's also what allows you to resell things on Amazon. The education exceptions are where I want to spend a lot of the rest of our time. So these are, as they're called the education exceptions, they apply directly to educators. So the first one, 110.1, it allows for the performance or display of lawfully made works in face-to-face teaching activities at nonprofit educational institutions. So again, when we're talking about the performance or the display, as long as you're engaged in face-to-face teaching at a nonprofit educational institution, you are protected. Basically, the law is not interested in what goes on in your classroom. If we're talking about multiple copies, again, we're talking about fair use, but that is specifically addressed by fair use. So as a rule of thumb, whatever you do inside your classroom, you're protected there. Where it gets a little tricky is when we get outside of the classroom. And in recognition of that, the Teach Act was passed in 2002. And what that did was attempt to update the face-to-face teaching exception for the digital age. So it allows for digital transmissions of performances displays of lawfully made works, excepting those that are actually produced and marketed for distance education. So if it's a distance education project, you're probably not protected by the Teach Act. But as long as you're using amounts comparable to those typically used in live classroom sessions, and you're at a nonprofit educational institution, you're protected by the Teach Act. But again, it's only provided certain conditions are met. And with the Teach Act, the devil really is in the details. So these are some of the provisions of the Teach Act, which I'm not going to go into in great depth. But some of the most important ones are the performance of display has to be made at the direction or under the supervision of the instructor in a class session offered as a regular part of systematic instructional activities. Performance of display has to be directly related to the teaching content of the transmission. Reception has to be limited to students officially enrolled in the course, and the transmitting institution has to have policies regarding copyright and provide informational copyright materials to faculty, students, and staff. The transmitting institution also has to apply technological measures which prevent the retention of works longer than the class session and also the unauthorized further dissemination of works. And finally, materials have to include a copyright notice. So when we're talking about the Teach Act, we're talking almost as much about what the institution has to do as what you have to do. So if you're considering using the Teach Act, you probably want to meet with an instructional technologist just to make sure that you're covered. To help you with this, useful librarians have created checklists which will help you think through the Teach Act, which are available on the website. So I'll show you those at the end. So those are the exceptions. The last thing I want to touch on, and then we'll go to the website, are DMCA and HEOA. So DMCA is the Digital Millennium Copyright Act. What that actually is a safeguard of protecting online service providers from monetary damages in the case of copyright suits. So an online service provider, AOL, has millions of users, or used to have millions of users. They have millions of users. So if they could be sued every time one of their users violated copyright, they could easily go out of business overnight. So the DMCA was passed to protect them, to free them from monetary damages in these cases. According to the definition of an online service provider in the DMCA, McDaniel College and most other colleges and universities are an online service provider because they enable people who are faculty, staff, and students to access the internet through the institution. So this definitely applies to us. And to qualify for protection, OSPs must comply with notice and takedown procedures. So what that means is if somebody finds that a user is violating copyright by, say, using peer-to-peer file sharing, they can tell McDaniel College that has to be taken down. They have to serve notice to the offending user and have them take that work down, deleted from their computer. The Higher Education Opportunity Act was passed in 2008 and imposes some additional requirements in colleges and universities, including an annual disclosure of copyright law and campus copyright policies to students, a plan to combat unauthorized distribution of copyrighted works using one or more technology-based deterrents, and a plan to provide legal alternatives to illegal downloading. So if you ever receive a notice, this is what's going on there. And McDaniel actually does a pretty good job of complying with these requirements. This is on the portal. My McDaniel, Technology, Policies, and Security, Copyright. So if you're curious about the procedures that we have in place, this is where you'll find that. So that is your overview of copyright as it applies to higher education. So like I said, I did create a website, since I know that was pretty quick, which contains more in-depth information and which you can use to refer to whenever you have any questions. So this is the landing page, and this will actually have the presentation I just gave. You'll also find contact information for Jessica Ferguson here. As you guys may know, this is actually my second to last day at McDaniel, but Jessica is going to be the point person for copyright after I'm gone. So any kind of questions, definitely feel free to ask her. What else you'll find here is an overview of copyright basics. So this would be a lot of what I just told you guys about. You'll also find a link to copyright law itself. If you click on that, you'll see the whole kit and caboodle, if you're curious about that. There's a section here for fair use. So I tried to answer some common questions and provide some more resources for thinking through fair use. What else you'll find here? On the top left, you'll find the fair use checklist that I mentioned in the form of a downloadable PDF. You'll also find codes of best practices, which I think are one of the most useful tools when we're talking about fair use. Different groups of people who are involved in copyright have gotten together and they've decided amongst themselves what they think are the best practices for their field. So if you are someone who is involved in academic libraries, you can click on this, and this will actually answer a lot of the specific questions that you might have in regards to specific policies. There's one here for media literacy education, which I like a lot. There's one for documentary filmmaking. There's one for poetry. A bunch of good stuff there. So that's definitely worth checking out. As I mentioned, you'll have some Teach Act resources. So again, I tried to anticipate some commonly asked questions. You have the Teach Act checklist, which I showed you. And you also have something called the Teach Act Toolkit, which was created by a librarian at North Carolina, Charlotte, which is a really, really, really useful resource. I can't recommend it enough. It'll give a nice overview of the Teach Act and answer any questions that you might have. And lastly, we have resources for faculty and staff. So again, I tried to think of different questions that I get a lot. I have a page exactly like this for students, which we'll add to as we get questions. But the main questions we get from students right now are, can I host a movie screening? We answer that. And what is the college's policy on peer-to-peer file sharing? And finally, we have a copyright news section, which we're trying to keep track of what's going on. As I mentioned, copyright is evolving constantly. So this is sort of what's new in copyright in higher education. So that's the website. We'll spend the rest of the session doing question and answer.